All right. Hello, everybody. Thank you guys for joining. My name, again, is Justin Stivers. I'm a probate attorney, owner of the Probate Law Firm based out of Miami, but we're active in about 17 counties, more or less, throughout the state of Florida. And we practice exclusively probate. So I don't do evictions, family law, divorce, bankruptcy, anything like that. We do exclusively probate, probate administration, probate litigation, and that's okay if you're not even sure what the word probate means. We're going to talk about that. I think I was at your all's brokerage a year ago. There's actually more people on Zoom than there was in person, so that's awesome. uh, but so anyway, so I guess I started doing this I've been doing this presentation for a little while, but there's I think probate in general is becoming more and more, I don't know if I say popular, but a lot more realtors are coming across probate listings, probate from the seller side, probate from the buyer side, uh, aging population in Florida, people passing away, and now their properties need to get sold. So chances are, at some point in your career, if you haven't already, you'll probably come across probate in one way or another. And so the goal of this kind of short presentation is not to make you all necessarily experts in probate, but I want to help you all identify when a property may need to go through probate. So when you're doing, kind of your due diligence and you're speaking with a prospective client or you're looking up a property or anything like that, how can you know whether or not you think the probate process is necessary? Second, I want to give you all enough information so that you can, when you're speaking with your prospective client, you can explain to them a little bit about the process, right? So, I don't remember the numbers, but it's something ridiculous. Like there's 55,000 realtors or something in South Florida. There's a ton of competition. I think, as you all know, not all realtors, just like not all attorneys, are created equal. And so the more information that you have, and I think that you can provide to your client, the more value you give, the greater the chances that you'll pick up that client. So I want to be able to give you all enough information. I definitely don't want you all practicing law, but I want you all to have enough information so that when you're speaking with prospective clients, you can explain enough about the probate process. And then lastly, we'll talk a little bit about how to find probate listings, how to market for probate listings, and that. So and I put my information in the chat box. Our website is probatefirm.com if you want to learn more information, but let's get to it. So I'm just going to quickly talk about a couple of definitions. First, what is probate? So probate occurs after somebody has passed away. So in order for there to be probate, it means that somebody has died. And in the terms in the real estate world, what that means is someone owned a piece of property. They were the owners on the property. They've passed away. And now either someone wants to buy that property or their heirs want to sell that property. And so what probate is we're taking that house, we're opening a court case, we're going to court, and at the end of it, the judge is going to say who is the owner of that house in order so that it can be sold and title be transferred to whoever the new owners is. So that's what probate is. Whenever you hear it, it means, unfortunately, it means somebody has passed away. A couple other terms, personal representative, or some states use the term executor. That's probably the most important thing for you all to know, because the personal representative, or we call them the PR, that's the person authorized by the court to list the property. The personal representative, that's the person who's going to select the realtor in most cases. That's the person who's going to sign the closing documents and all of that stuff. So when you are, and we're going to talk about that in more detail, but when you're working let's say on the listing side, you need to be very, very sure and very clear that you're working with the personal representative, because only that person, only the personal representative has the ability to list the property. And so the personal representative, just while I'm talking about it, actually has to be named by the court. So it's not enough that somebody just comes up to you and says, my mom passed away. I'm the only child. She had a will and she named me as the personal representative. That might be true, but we still have to go to court. And at the end of in the process, the judge is going to say is going to sign a piece of paper naming them as the personal representative. So that's very important. Last will and testament. I just talked about that a second ago. A will, you guys are probably familiar with it. But a will is a piece of paper, document that you write down that says who gets your stuff after you pass away. Right. So very simple. And we'll talk about that. One thing I can say at the beginning, though, is having a will, just by having a will, does not avoid probate. So a lot of times people will come to our office and they'll say, look, I have a will. My mom left me the house. And I tell them, unfortunately, they can't go to the property appraiser, the county, and say, look, here's a copy of the will. The county's going to say, go hire a probate attorney, and you have to go through that process. So having a will does not avoid probate. And last term to mention is what we call an estate, 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 and that's just what we refer to all of the things that a person had when they passed away. So John passes away. He had a house, he had his car, he had bank accounts, he had jewelry, whatever it is. We refer to all of that as the estate of John, the estate of John, whatever his name is. All right. And again, if you guys have questions throughout this, just put them in the chat box and I'll try to answer them as we go along. But all right. So for section, number 1 is, how do you guys know when a property is going to go through probate, right? How do you know that? Most of the time, when you all get I'm coming at this from the listing side of things. Maybe some of you really prefer working with the buyers, but I find most realtors would rather work with the seller. So if you're going to get a listing, most of the time it's either going to be referred to you. Someone's going to call you and say, hey, I want to sell this property, or whatever the case may be. In probate, if someone calls you and says, hey, my mom just passed away, I want to sell her property, well, that's a kind of a clear indication that probate might at least be necessary, right? If you at least know that somebody has died, then chances are probate's going to be necessary. But most of the time, what's going to happen is you're going to be, someone's going to get referred to you, and they're probably not going to say, hey, the owner of this property has died. And you've got to do a little bit of digging to figure out what the next steps are. And most of the time in your normal course of business, I bet you go to the tax roll, the county, the property appraiser to see who the actual owner of the property is. And that's similar where I'm going to start here is. So I'm going to share my screen just so that you can see a couple examples that we're going to go over. Okay. So, and if you are on your phone and without using Zoom or looking at this, again, just email me, justin@probatefirm.com, and I'll email it to you, but I can explain this. You probably don't need to see it necessarily. Okay, but here's an example of one that has to go through probate. So I'm looking at the property appraiser's website on a property, and in the owner box, it says Maria Pichardo, and after that it says EST of. Okay. That EST of stands for estate of. Like I said in the definitions, estate just kind of means that's what, when someone passes away, that's kind of how we refer to that person. Maria died. We don't really refer to her as Maria anymore. We refer to her as the estate of Maria Pichardo. So in this case, a probate was necessary. So Maria owned this property. She passed away, and now the county reflects that EST up. So if you're ever looking at a property appraiser or tax roll and you see that EST of, 99.999% chance you have to do a probate before the property can be sold. So if you were to come across this listing and you saw that, you would need to do a little bit of investigation before you just go and list the property. So when does and just this is kind of an aside, when does the county update this? When do they put the EST of on there? Unfortunately, I'm not really sure. I've called the county, I've called Vital Statistics, who records death certificates, and there's no real definitive answer. What happens a lot of times is someone passes away and their kid is still living in the house, but they weren't on title. So they want to get the homestead exemption, right? They want the tax exemption. So they'll go to the county and they'll say, look, this is my address. I live here. My mom passed away. Can you put the property in my name so that I can get the homestead exemption? And the county says, sorry for your loss. You don't own the house. Go get a probate attorney and you're going to lose the homestead exemption. So that's sometimes when that happens is people go notify the county themselves. But anyways, if you see that EST of, again, this is, the probate might already be opened. It might already be started. It doesn't mean that one hasn't been started, but before you go list the property, you need to do a little bit of research to find out, hey, has a probate been started? And then if not, try to get one started. Because if you go to list this property and then you try to sell it, you're going to have issues at title, at closing. You're not going to be able to sell it. So this is probably the most common example that you'll see. Okay. Second example. So again, if we look at the owner, we've got Jesus Silva, EST of, and then Maida Silva. Again, the EST of stands for estate of, meaning that Jesus has passed away. So in this case, there were two people on title, Jesus, the father, and Maida, the daughter. Now we're going to talk about different ways that people own property, and you all are probably familiar with joint tenants with right of survivorship and some other things like that. But in this case, Jesus, the father, and Maida own this property 50-50, meaning Jesus was not married at this time, and Maida was his only daughter, no other kids. So this was I think this was an investment property or rental or something. And Jesus passed away and Maida wanted to sell it. So she gets a realtor, they put it on the market, they spend a couple months, marketing the property, they go under contract, they go to the closing, and the title agent says, okay, Maida, you own 50%, but did you do a probate for your father? And Maida says no. The realtor says no, we don't need to because I'm already on title. I own 50%. I'm the only daughter. He wasn't married, et cetera, et cetera. Unfortunately for them, they had to go do a probate, spend another couple of months doing the probate process before the property got put 100% in Maida's name. So this is pretty common in, most places, but you'll see a lot of times in South Florida where brothers and sisters own a piece of property together and they don't have certain language on the deed. So kind of moral of the story with this example is, again, if you see that EST of, or if you know that somebody who was on title died, it's not automatic that the other person who's on title automatically inherits the property. For example, I just had before this presentation, I was on a call with a prospective client. He called me. His brother passed away. They had an investment property in Hollywood, and him, his brother, and his sister were all on title, but they didn't have certain language on that title, on that deed. So now they've got to do a probate for the brother who passed away. So how could you? What I keep mentioning language in the deed. So the most common one is it's going to be joint tenants with right of survivorship. or it might say JTWRS after some on the deed. And what that means is if you have language in there, it would say something like Jesus Silva and Midas Silva with joint tenants and right of survivorship. If you've got that language on there, if it says that, then when one of the owner passes away, the other owner who's still alive automatically inherits that property and probate would not be necessary. So for example, if this property had said that, then when Jesus died, Maida would have automatically inherited the property. She would have received it and she wouldn't have had to have done probate. But because it didn't have that joint tenants with right of survivorship language on there, probate was necessary. So if you put that language on the deed, that's a way to avoid probate. Another one is spouses, so husband and wife. If you are married and your deed says, generally it's going to say, John and Jane, a married couple, or John and Jane as husband and wife. If it's got that language on there, if one of the spouses dies, if the husband dies, if the wife dies, the surviving spouse automatically receives it and they don't have to do a probate for the spouse. So that's pretty common. But what happens a lot of times is, or what I see a fair amount is, maybe the spouse, one of the spouses had a piece of property before they got married, and then they get married and they don't put the spouse on title. A lot of times you'd have to do probate for that one. So again, it really comes down to what the deed says. There's other types of deeds, which, just to keep things kind of short and simple, I won't go in too much detail here, but you can do deeds such as life estate, what's called a ladybird deed, where you put somebody on the title. They don't have any ownerships while you're alive, but when that owner passes away, the other person automatically inherits it. So there's ways that you can avoid probate by having the deed changed. And so that's common. But this, again, if you see the EST of, no, that probate's probably necessary. And then the last example I was going to give you all about, this is how to avoid probate, is you can put the property into a trust. So in this case here, you see the TRS after the person's name. That stands for trust. And so in this case, and then the BEN stands for beneficiary. So in this case, the property at one point was owned by Karen Rodman. She did a trust, right? So here she did a trust and she transferred the property into the trust and she named someone else as the beneficiary. And so in this case, when Karen S. Rodman passes away, her beneficiary does not have to go through probate because there's a trust. And so the property would automatically go to whoever her beneficiary is. Trusts are great tools for a variety of reasons. If this was a longer course, I could go, more into, I always get a lot of questions about trust, but one of the main benefits of having a trust when it comes to property is avoiding probate. So trust is a two-step process. We do first we're going to do the actual trust. So we've got the trust document. Then we're going to go and take the property. And if it's already in somebody's name, if it's in, my name individually, if it's in Justin Stivers' name individually, I'm going to do a new deed and transfer the property from Justin Stivers individually and make the Justin Stivers trust the owner of the property. And that way it avoids probate. So again, a great tool, a great way to avoid probate. Having a will, just having a will is not going to avoid probate. So again, big, common misconception. Wills are great for a variety of reasons, but for avoiding probate, they're not. So those are kind of ways to know whether or not probate is going to be necessary. And again, your job at this point would just be to identify that and then bring in your professional, your attorney, whoever you're going to bring in to help out. But before, I see a lot of times where a realtor, gets excited, they get a listing, they're ready to go list it, and they spend all this time And then they get to closing and realize, oh crap, we can't actually sell it until we do probate. And now you've kind of wasted a bunch of time, and the client might be, might be pissed off. So something to look at. So I'll pause for a second and see if I see any questions, if you guys have any questions about that. So someone wrote, thank you, Wesley. Someone wrote, so if a person writes a will and wants to convey a property upon death, what is the correct way to do that? Well, it's kind of talking about those examples that I was just kind of going through. We're probably, if we want to avoid probate, in a will, you can say who gets your stuff, right? So I could write a will and I could say, I want my brother to get my property, to get my house at 123 Main Street when I die. I could do that. But when I die, my brother who has my will is not going to be able to go and put the property in his name right away. He's going to have to hire an attorney, go through the probate process and all of that. So it might be better if I do a trust that and leave the property to him in the trust. So that's, or put him on the title if I want him to be on title as well. All right. So we kind of talked about, how to identify when a property is going to go through probate. Let's assume now, part two, that probate is necessary. So we know that probate's going to have to happen. Like I said in the very beginning, a lot of realtors, a lot of competition. So that's the bad news. But the good news is there's a lot of room to really stand out from your competition. And one of those ways is, I think, by providing, value and providing information that they might not know about. Because again, a lot of people, they don't even know that probate's necessary. When their mom or dad dies, they just, they think automatically they get the property. They don't realize that they're going to have to do a probate. So if you can explain a little bit about the process to them, I think you're really going to kind of stand out for them. So when you're going to meet with them, like I said, the main thing, the person who will be hiring you most likely is the personal representative. That's the person who's going to be named by the court, the person in charge of kind of doing this entire process. So I always recommend that the realtor, when they go and meet with someone, you want to ask them two questions. So first, you want to ask them if they had a last will and testament. So did they have a will? And the reason is, let's say that you're talking with brother. Let's say that you're speaking with the brother, and the brother's like, oh yeah, I was taking care of my dad. He was sick. He told me I was going to get everything and whatnot. But it turns out there's a sister, and dad had a will and he left the property to the sister. Well, now you're kind of wasting your time speaking with brother, because one, he's not even going to get the property, and it's going to be the sister probably who's going to pick the realtor. And so I've seen that, it's kind of sad, but sometimes I'll see a will, or I've drafted them even, where the person writing it says, hey, I have 2 children. I leave everything to my son. I specifically don't leave anything to my daughter. Or I've seen one that said, I leave everything to my daughter, but I leave $5 to my son just so that he knows I've not forgotten him. Pretty messed up, but it definitely, it can happen. So you want to find out, ask if they have a will, again, because you want to make sure that you're speaking with the right person. If they say they do have a will, the next thing you want to ask is if they have a copy of it. So yeah, I have a will. Okay, great. Do you have a copy of it? And the reason is, again, your job is not necessarily to read the will and interpret the will. That's the attorney's job, but it's just kind of helpful information. The reason you want to ask is wills are not generally recorded. So there's not a master database that I can go to, that any attorney can go to try to find out if somebody had a will. And I get this call every month at least, where someone will say, hey, I think my mom did a will. I just don't know where it is. I can't find a copy of it. Well, I can't, again, I can't go to will.com and find out if somebody had a will. That doesn't exist. So if they don't have a copy of it, there's not much that we can do. They're generally not going to be recorded with the court. They're generally not going to be, there. So we want to know if they have a copy of it, because if there is no copy, there's not much we can do there. All right. And then after you've asked those questions, ask them what the relationship is to the person who passed away. And what I mean by that is this your mom? Is this your dad? Is this your brother? Is this your tío? Is this like, who is this, right? So what relationship is this person to you? Again, reason is if there is no will. So if there is no will, Florida law has a preference, a priority of who gets to be the personal representative. First, it's going to be the spouse, then it's going to be the children, then it's going to be the parents, then it's going to be the brothers and sisters, on and on and on until you get to second, third, fourth, and fifth cousins or uncles and people like that. And so a lot of times you'll have somebody who, let's say it's the uncle. Let's say uncle comes to you. Why the uncle comes to you and says, I've been taking care of my brother all this time, and his kids left, and we don't know where they are or whatnot, so I want to be the representative. Well, unfortunately that doesn't matter. Even if these kids were terrible children and stole money and moved away and haven't seen their parents in 50 years, it doesn't matter. They're still going to have preference to become personal representative and to inherit this. So that's why we want to ask, what's the relationship? Because again, if this is second, third, or fourth or fifth cousin, chances are they're not going to have preference to be the representative. So again, that's one of the important things we want to know. Question: so why is a will not recorded? Don't really know the answer to that. You would think they would have something, but they're unfortunately they're not. I could do a will, put it in my drawer back here. If I die and I don't tell anybody that I had a will, no one knows. Nobody's gonna know about it. All right, so talking a little bit about the process, length of time, and what you all need to know. So for the most part, if you all are going to list a property, it's not a whole lot different than any other listing, any other transaction that you guys are going to do. There's a couple things to know. Again, when you're signing the listing agreement, or when the as-is contract is being signed, it needs to be signed by the personal representative. So if Justin Stivers, if I'm the personal representative, when I go to sign that contract to sell the property, I'm going to sign it Justin Stivers as the personal representative. When I sign the listing agreement, I'm going to sign it as the personal representative. So that's really the kind of the main thing that you guys are main difference that you all are going to have. So how long does the probate process take? Well, in most cases, there's really two different examples. First is if the person died recently. So if the person died within 2 years, right? So we're in 2020 and the person died in 2019. Most of the time, the probate's going to take between 6 to 7 months from start to finish. It's going to take us about 30 to 45 days to get the personal representative appointed. So when we start the case, it's going to take about 30, 45 days to get the representative appointed. Then in Florida, we have to wait 90 days. And so there's this creditor period that we're waiting after the representative has been appointed. So let's say that John dies and he owes money to American Express, Baptist Hospital, Home Depot, wherever, right? So someone dies and they've got outstanding credit card bills, and hospital bills are the most common. Those creditors have 90 days to notify us, the attorney, that they're owed money. And so after the representative is appointed, we're going to put in the newspaper that a probate has been opened, and those creditors have 90 days to come forward and tell me, the attorney, that they're owed money. Doesn't mean they're going to get paid any money, but we have to wait that 90 days before we can sell the property or do anything with the property. Once that 90 days is up, then we can transfer the property to the beneficiaries, and then they can sell the property, or we can ask the court to approve the sale of the property. Really just depends. So that's why, on average, if the person died within 2 years, so it's been more recently, probate's probably going to take about 6 to 7 months. Real quick on the creditors, on the creditor piece, if there is no money, so I get asked this a lot. So let's say someone dies and they just don't have any money. They didn't have anything. Well, Visa can't come after the heirs, the children, to try to get repaid for the most part. If the kids are joint owners or on the account, they open the account, they could possibly. But most of the time, someone takes a credit card out in their own name. Visa, American Express can't come after the children for those bills. For the most part, they can't come after the house either. So in a lot of these, what you'll probably have is you're probably going to have a homestead property, meaning it's their primary residence. If it's a primary residence, meaning it's not an investment or property, you live there the majority of the time, you get the homestead exemption, creditors can't touch that homestead property. So if Visa, if American Express, if Baptist Hospital, if they're owed $100,000, they can't force you or the heirs to sell the property to get paid back. If that property gets sold, they can't get any of that money. That's exempt from creditors. The only people who could really go after the homestead property are, unpaid property taxes, mortgage companies for mortgage payments, the IRS potentially, but normal, creditors like Visa and that sort of stuff, they can't touch the property. Okay, so Wesley's question. So once you have court approval and you find a buyer and the 90-day creditor period has passed, you have to submit the contract to the court for approval as well. So it depends. If it's a homestead property, right? So I've been talking about homestead. If it's a person's primary residence, I'm not going to get court approval to sell the property. What I'm going to do is at the end of the 90 days, once that creditor period is up, I'm going to ask the judge to sign a new deed saying who the beneficiaries are. Once the judge signs that deed, the property is no longer in probate and the new owners can sell the property. And you don't even need court approval. So if this is a primary residence, let's say I'm inheriting my parents' property and I want to sell it. I got to wait that 90 days. At the end of the 90 days, I'm going to ask the judge to put the property in my name. Once the judge puts the property in my name, now I can sell it as if I was selling any other piece of real estate. I don't need court approval. I don't have to give them a contract. I don't have to do anything like that. I can just sell it. If, however, it's an investment property or it's a second property, it's a non-homestead property. If I want to sell the property within the probate, and there might be a reason to do that, then yes, I'm probably going to have to get court approval to do that. So I'm just thinking of an example. So for example, the client that I was speaking to, well, prospective client that I was speaking to before this, they don't know if it's a second home. These people actually live in a different country, and they may or may not want to sell this property in Hollywood. So it's not a homestead property. All we're going to do is we're going to put the title in their name. Once the title is in their name, it's no longer in probate. And if in 5 years they decide to sell the house or the condo, they can do that. They don't need me. They don't need the court. They can just sell it as if it's all I'm doing at that point is transferring the property into their name. So that example was if the person died recently. If the person died more than 2 years ago, so let's say, again, we're in 2020 right now, and the person died in 2016. All things are pretty much the same. It's still going to take us about 30 to 45 days to get the personal representative appointed. But after that, there is no creditor period. So after that, after the representative has been appointed, we can either, one, ask the court to transfer the property, the homestead property, to the new owners, or ask to sell the property if that's what we're going to do. And the reason why we don't have to wait that 90 days is because there's kind of a time limit on when creditors can make any claim. There's a 2-year time limit on when they can make a claim. So again, if someone died in 2016 and those creditors never made a claim and we open the case in 2020, they're not, we can just ask to sell or transfer the property right after the representative has been appointed. So it's probably going to be a lot shorter. It's probably only going to be 2 to 3 months from start to finish if the person passed away, again, more than 2 years ago. All right. Any other questions on that? So again, I would say most of the time it's more common that you're probably going to be dealing with a probate that's more recent. I mean, it does happen where, you know, you don't have to do a probate at any given time. So for example, we had a case where it was a couple of pieces of vacant land up in North Florida, Georgia border, and just vacant property. And the guy had died in like the 1940s, 1950s, and the family had just been paying the property taxes all this time. And now finally they wanted to sell the property, but we had to do a probate. And at that point, it was a lot more difficult because there was, like, not exaggerating, 50 plus different heirs who were all going to own this piece of property. But there's no time limit. You can do a probate whenever, so long as, you know, for when it comes to real estate, the main thing is so long as the property taxes are getting paid, you can keep it open. You know, you can have it never done. But when it comes to creditors, they've got to file a claim within 2 years. So, but most of the ones that you'll probably be finding are when someone passed away more recently. And so you'll have to wait that 90-day creditor part. Let me see, what have we not hit? Costs, I get asked this a lot. You know, I'm hesitant to, you know, say, hey, tell them it costs this much, but generally, you know, attorneys are going to charge in a couple different ways. They're going to charge an hourly rate. They're going to charge a flat fee. They're going to charge a percentage. I would say most probates are going to fall between the $4,500 to $8,500 range, somewhere around there. But again, I probably wouldn't, I probably wouldn't tell the prospective client that, but that's, you know, for your ears only, I suppose. All right. Any other specific, I'm trying to think if I'm missing anything that I wanted to keep us on track. All right, I'm not seeing any other questions. So, all right, so then we'll talk, you know, just briefly about, you know, maybe some marketing ideas, some things that I've seen trying to find listings and whatnot. So there's a couple things you can do. Most of this information is public record. Most of this information is public. Once an estate has been opened, that information becomes public record, and you can find the address and sometimes the telephone number of the personal representative. And so the personal representative, like I said, is probably the person who's going to choose the attorney. So you can go to, you know, Miami-Dade Clerk of Court, Broward, Palm Beach, all of these, and get this information, or go to the courthouse. Well, I don't know if you can now, but access the records yourself and get that information. And then you can either call and or send mailers. The one thing and I know that works. The one thing I would suggest, though, is remember that this is somebody whose probably parent just passed away. So if you're like using what I would maybe consider kind of normal realtor tactics of like, hey, we've got cash buyers fast, close in 20 days, that might not be the best approach if you're reaching out to someone who, you know, because this might be a family home or something like that, or there's fighting with siblings. So I've seen, you know, I've gotten letters because I'm the representative in a bunch of cases, and the attorney is public record. So you can find out who the attorney is for the probate. You might want to say, hey, I'm experienced in probate. I'm familiar with the probate process. I've got my team that I work with. I have people that clean out the houses. These are a list of the other attorneys that I've worked with. So build up your, fake it until you make it, but build up your credentials. And again, like I said a little while ago, a lot of times these clients don't even really know that they didn't know probate is necessary. And if you can kind of present yourself as like the probate expert, like the probate guru, the probate, the realtor who specializes in probate, it's kind of like anything. Like if you're going through a probate and a realtor, it's just like a normal realtor at whatever brokerage, and then it's, Justin the probate realtor, it's like, oh, well, that's what I need. I need a realtor who really specializes in probate. So you can kind of, brand yourself in that way. But again, I think if you can buy the lists. I know you can buy lists of personal representatives as well. I don't work with any of them. I'm not sure how effective that is, but I think it can be effective. Again, there's about, in Miami-Dade County alone, there's about 250 probates filed every month, more or less. So it's a pretty big industry, and there's not a whole lot of realtors who I would say really specialize, who really specialize in probate. So I think there's kind of an area to really niche yourself and be known for this one area. Now networking is difficult, but again, speaking with other attorneys, other probate attorneys, like I said, that, most every probate that we have involves a piece of real estate. So, and I know I'm definitely not the only probate attorney. There's a ton of them. So you can network with other probate attorneys. And I know, myself, I like to work with other realtors who know the area, can, manage the clients. That's one of the biggest thing, right? And especially from the seller side of things, you've got to buy, if the buyers don't really understand the process, because this, unfortunately, it's not hey, we close in 30 days. Stuff can happen. There can be fighting siblings. And like I said, in that example, it's probably going to be about a several month process. And if the buyer's agent is like emailing me every day, like, hey, what's the status? What's the status? It can get super annoying. So if you can kind of manage the buyers and say, listen, if your client needs to move in within 20 days, this might not be the property for them, because it does take a little bit of time. I don't want that to necessarily scare you all off from it, because again, I think this is a huge opportunity. But that would be another way that you could do it. And then there's one other, I think that's, let me see, so can you do a probate yourself without an attorney? In some cases, yes. In some cases, the courts will require an attorney. I tell this to my prospective clients who would maybe ask me that. I would probably say, I could probably change the oil of my car if I really wanted to. One, I don't want to. And two, I'm probably going to mess something up, and it's going to take me super longer than if I just paid someone to do it. So it depends. Yeah. I mean, there are some instances where you could probably do it yourself, but depending on the complexity and the speed and all of that, you're probably going to want, if you're talking about selling real estate in it, if there's real estate involved, you're probably going to want to hire a professional. And then my email was in the beginning, but it's easy, justin@probatefirm.com, and just go to probatefirm.com to get my phone number and other contact info. So rushed through that to get everybody out. I thank you guys for tuning in on a Friday. I don't know if anyone had anything else. Wesley, I think, did you set this up? Was that? Let me see if I can. There we go.
Hi, so I actually am Denise, but I was logged in under Wesley because
okay.
the account. But yeah, no, you answered my question, because I was actually going through